Anytime an abuser has a firearm, that woman is 5 times more likely to be shot and killed.
Welcome back. The case United States versus Rahimi centers on Zaki Rahimi, who is charged with violating a federal law that stops people who are at the subject of domestic violence restraining orders from owning a gun. Now, Rahimi says that law violates his Second Amendment right, but many coalitions against domestic violence are concerned that if they rule in favor of him, that it could put victims in danger. So joining us now, we have State Representative Brian King joining us to talk a little bit about this. Thank you so much for joining us today.
Oh, you're welcome.
So you worked with Lieutenant Governor Deidre Henderson on passing a bill that limits firearm access for abusers. What exactly did that entail?
Well, it made it more clear that if you had been convicted of or had had charges that you pled guilty to for domestic violence, that you were put on a prohibited list, a list of individuals who can't own firearms. And that was an important thing because we know that individuals who are engaged in domestic violence are much more likely, if they get their hands on a gun, to kill their domestic partner, and we, of course, want to do what we can to avoid that from happening. And
I know you've been paying close attention to the arguments that have been made today. What is your impression at this point? Well, what happened is the Fifth Circuit Court of Appeals said, we don't think that states can regulate individuals and prevent them from getting guns even though they've been convicted or accused of domestic violence. And the Supreme Court in oral arguments today was very skeptical about that idea. They said, well, it's true that domestic violence wasn't something that is well established as being part of the historical tradition at the time the Constitution was formed in 1789, but there are legitimate reasons that governments want to protect individuals. We want to make sure that individuals who have been convicted of domestic violence are not able to put their hands on a gun because we know that there is a very high rate of death and injuries that result when those folks are able to get a firearm and use it in their domestic lives. And this is something that we come across regularly with the U.S. Supreme Court, where they are discussing how they can honor our Constitution, but a lot of what is in today's society wasn't there at this time, so it creates a unique challenge for them. Yes, and this is a perfect example of that. Back in 1789, there was no such thing as domestic violence. Men in particular could treat their spouses or their children or their slaves any way that they wanted to, and that was not something that the law interfered with, or we didn't take guns out of people's hands because they were maybe engaged in domestic violence. But times change, and we know now that guns, as the story that you had before our interview here said, if you allow individuals who are prone to domestic violence to have a gun, the likelihood that they kill their partners or that they injure them seriously is really, really much, much higher than if they don't have a gun. So it's legitimate to say we're going to identify individuals who have been prone to domestic violence or been convicted of it, and we're not going to let them get a gun. And the Supreme Court was sympathetic to that argument today. And you have mentioned that, but if the Supreme Court does rule in favor of Rahimi, do you see any future legislation for Utah specifically that can address this issue? What are your plans? Well, the Supreme Court is addressing the U.S. Constitution, and if the Supreme Court says that it is unconstitutional to keep domestic violence abusers from getting guns, it's going to be hard to regulate who gets those guns when they're accused of domestic violence, when they're convicted of it. So we don't have a lot of ability in the state of Utah to circumvent, get around rulings from the Supreme Court about what's unconstitutional in the United States Constitution. So there's nothing we can do if that happens? It would be difficult. It depends on, of course, on what the U.S. Supreme Court says in this decision. Mm-hmm. But if they came out in an extreme example and said, look, domestic violence wasn't illegal in 1789, and so therefore we're not going to allow the state to regulate it today, that would be a very difficult thing for us in the Utah State Legislature to change, to get around that ruling from the Supreme Court. And that's one of the reasons I don't anticipate the Supreme Court's going to go that far. And the ruling, or rather the oral arguments today, suggested that, in fact, they won't go so far, that they will continue to allow some room for states and the federal government to regulate when domestic violence abusers get a hold of guns. All right, Representative King, thank you so much for joining us and talking about this. All right, stay with us. We'll have a look at your full forecast coming up right after this commercial break.